Hello, hello, h- hello, hello, hello. Film clatters on the voice. Pause on the. The advertising you do. ప్రపంచానికి కనిపిస్తుంది. ఆడ వచ్చారు మధ్యలో అది కనపడదు.
నా క్లాస్ వినండి, నా క్లాస్ వినండి సిన్సియర్ గా. గుడ్ మార్నింగ్ లేక్యా.
Stand right. Good morning to all. We are on time. So everyone is okay with notice so far. All the things is clear, right? Yes or no? Shall we begin? Today we will learn about how to frame a civil suit. Okay. So what are the rules and what are the... Yes, ma'am. Matradika. It's on, it's on. So today we'll learn all the general principles on framing a suit. Okay. Guys, please settle down fast. Okay, we'll begin. While framing a suit, what all are the general principles that has to be followed is what we'll learn today. There should be parties. Two parties, that is the person who's filing the suit is the plaintiff, and against whom it could be one or more person, and it should be the defendants. Okay. And while framing a suit, what all things has to be included, what all things has to be there in the suit is what you have learned under which order of CPC. Framing of suit is dealt under which order of CPC? Order? Then what does order 7 says? I'm asking under which order is framing of suit is dealt under. If it is order 7, what is order, in which order plaint is being dealt? Order 7 is plaints, and order 2 we learned about the framing of suits. So in under framing of suits, you will learn around how many 7 rules, which is very important that we will just skim through the rules so that you will get an idea before going into deep. Rule 1 of order 2 says that every suit shall, as far as practicable, be framed so as to afford ground for final decision upon the subjects in dispute and to prevent further litigation concerning them. What does that mean? There are 2 points that is given under rule 1 of order 2. One is we have to frame a suit in such a way that it avoids further litigation, and it also should give a ground for final decision. Okay, why? Because if we at first instance, for one relief we file a suit, and for another relief we are filing a suit, what happens is there will be multiplicity of suits. More than n number of suits is there. So the first thing you have to make sure, while a client or someone comes before you for a relief, make sure you hear them, you properly listen to their claims or whatever reliefs they want, and all those reliefs, if it is of coming out of the same cause of action and against the same parties or multiple parties, then those cause of actions and everything has to be summed up and to be framed in that single suit alone. Why? Because it will be barred by res judicata. You will not be given an opportunity to file for the same cause of action and against the same parties another reliefs thereafter. So while you framing the suits, that is the fundamental principle. While framing a suit, you have to frame a suit in such a way that it should be giving a final decision. The court we should be able to give you a final decision, whether it is an injunction, whether it is an attachment, whether it is for a declaration of any suit or anything. Then it should be all the reliefs has to be claimed. Whatever reliefs you wanted to claim must be stated. So that why? Because you have to avoid multiplicity of suits. Okay, then suppose if you have omitted, if there was an omission of asking any kinds of reliefs, what is your fate, or what is the fate of the other reliefs? You cannot hereafter claim for it. That is dealt under order 2 rule 3 of CPC. That is omission to sue for one of several reliefs. If you fail to omit, or if you fail to ask for the relief, then you will not be hereafter able to ask for the specified relief. Why? Because of the same cause of action as well as against the same parties. I shall read rule 3. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs. He has the right, he has a right to make sue for all the reliefs under the same cause of action, except with the leave of the court. To sue for all such reliefs, he shall not thereafter sue for any reliefs so omitted. If he has omitted any reliefs and he failed to add the relief, then he will not be able to contest, provided with the leave of the court. But if the leave grants the permission, then he is liable to, then he gets an opportunity to sue as well. So the first thing you have to see, there are parties to the suit, the plaintiff and the defendants, and you have to frame the suit in such a way that it avoids multiplicity of suits and gives final grounds for final decision. And whatever reliefs you have to claim for the same cause of action as well as against the same parties has to be claimed in that specific suit itself. Next is the jointer of cause of action. What do you mean? Against the same party, there may be one or more causes of action. Maybe the money he has obtained, he has borrowed a sum of 10 lakh rupees. In order to secure, make a security, he must have issued a check, which is maybe after 1 month, he might have issued that check for 10 lakh rupees to the same party. He might have caused any breach. Because of dishonor of check, there was a breach. So these are all the multiple cause of action against the same parties through in the same transaction throughout because between the same parties it has happened, right? So all those cause of action must be joined together while framing a suit. Understood. Because it is against the same party, and what is the relief we want? 10 lakh rupees that has been given. So all these causes of action must be joined together. And another thing is, I told you about the parties, right? It is important that you have to join the necessary parties in a suit. If a necessary party is not included in the suit, it can be a ground for rejection as well. Remember order what order which one? Order 6, order 7, rule 10. 1 second. 11, 11, 11, right? Yes. Yeah, order 11, rule, yes, orders 7, rule 11, rejection of plaint. So while the causes of action you should also make sure causes of action has to be joined properly. Then so these are the important things that you have to with regard to framing of suits. So first thing is parties to the suit. Second thing is, what is the second factor? Huh? Cause of action. Then yeah, you cannot later on claim for the things which you have omitted. So all the reliefs has to be asked in the first instance. Then joiner of causes of action. So these are the important factors that has to be kept in mind while framing a suit. And also, as I said earlier, while in last class, while framing a suit, you have to make sure the how you frame the cause of action. That is the place and when it was the cause of action arose. Why? Because we are asking to mention correctly the place as well as the time or when the cause of action arose. Correct, exactly. For understanding for whether the court has jurisdiction to try the suit or not, in order to analyze that only, we have to, and there should also state a statement that the court has a right to, as a jurisdiction to try this suit, since it is coming within the same jurisdiction and so on. That thing has also to be mentioned in the while framing a suit. Okay. 1 second. Now shall we draft a plaint? Yes. Now, do you know the pecuniary, have you heard about the pecuniary jurisdiction? What does it mean? Money value of the suit. So what is the pecuniary jurisdiction for the lower court? That means what we say, like in Kerala you say municipal court, what do you say in Andhra Pradesh? Like lowest court, what is the lowest court called here? Huh? Municipal court only. Civil judge. Principal junior civil judge. So what is the pecuniary jurisdiction for that court? Huh? 10 to? That's it. Okay, what depending upon the pecuniary jurisdiction of the court, we will file in which court we have to do it. For example, in Kerala, it is up to 10 lakh. It is the municipal court, and above that, it is the sub court, subordinate court. So here it is around 7 lakh. What is it? 3 lakhs. Up to 3 lakhs. Okay, so while drafting the plaint, the first cost, that is what we say the cost title, before the honorable so and so court, depending upon the court in which we file the suit, that first we have to write is before the honorable court. For example, before the honorable junior principal junior civil judge, what is it? Principal junior civil judge. So before the honorable principal junior civil judge, that is what the cost title, what the title of the forum will be given. Next, what we have to write is what kind of suit it is. Is it a like OS? Is it an original suit, or is it an original petition, or it is an OPMV, that is whether it is a motor vehicle petition, or it is an OPHMA, that is whether it's a Hindu Marriage Act as per the petition as per Hindu Marriage Act, or whether it is an IP, insolvency petition, or likewise the suit name has to be given. For example, OS number dash slash of the year of the suit in which we are filing. So after the name of the, at the back, please settle down. First is the name of the forum. Next comes the which kind of, what kind of suit that we are filing, that whether it is OS, OP, or whatever it is. Then comes the plaintiff and defendant. Here you need to mention the name alone is enough. Just the name. For example, plaintiff Mr. X. If there is more than one person, here you need not write the whole name again. Either you can write X and another, X and 3 others. How many persons are there, like that way. And the next line we have to write defendant or who are the other person, and Y and another, or Y alone, who are like that way. Got the idea? Before the honorable so and so court, OS number so and so, plaintiff is name, and defendant their name. Then you have to write the, what you have to write? No, under what rule or under what section you are filing this petition or the plaint. So plaint filed under which section and which rule of CPC? So you have to write plaint filed under section 26, order 7, rule 1 of Code of Civil Procedure. That should be in the center. If there was a PPT, I could have shown you this, but in the record it is given in detail. Okay, so after giving the names, then you have to give the title on the cause, like plaint filed under section 26 and read with, you have to write R.W, or you can write read with also. Read with means read along with section 26 and order 7, rule 1 of Code of Civil Procedure. Then what you have to write is in detail the address of the plaintiff. Got it? Then again also you have to, first I mentioned, we mentioned only the name of the plaintiff. Again we have to write the plaintiff, his name, Son, age is also important. Age, son of, and his address, everything. After what? After the plaintiff, you have to write a statement, state like the notices or above any kind of services has to be served in the above address or to the counsel if he may engage. That has also been written. Now, the same thing has to be repeated again with regard to the defendant also. If there is n number of defendants or n number of plaintiffs, or each and everyone's address should be mentioned. Got it? If even if there is more than 20 also, all the 20 defendants, all the 20 plaintiffs' address has also to be stated. And the same dialogue has to be given again. All the notices, processes, everything has to be served in the above mentioned address or to the counsel which he may engage. Okay. So far this is clear. This will come in the first page. The heading of the name of the court, name of the forum, the type of suit that you're going to file, whether it's OP, OS, whatever it is, everything has to be mentioned. Then comes the name, the plaintiffs and the defendant. Then comes the under what you are filing this plaint. So even if it is that IA, we have to write what is the order for the IA. That is an interlocutor. That I will take it separately. But this is the same format that you have to follow there as well. All the things that in IA it has to be followed by an affidavit also. Plaint also you have to file an affidavit, and plaint by filing you have to file in duplicate. Otherwise, it is also a ground for rejection. Got it? So that is the front few things that we have to see to it. Next is you will go into the fact. Before that, you have to write a statement. The plaintiff begs to submit as follows, or plaintiff humbly submits as follows. Then in paragraphs, as I told you in the earlier class, each and every paragraph is one point, and each point has to be numbered as well. Why? Because it will be easy, and it will be easy for denial also. For denying that the above or the allegations contained in paragraph 5 in the plaint is humbly denied by the defendant. For that sake only we are numbering the plaint, all the above in the plaint. So after writing this, the plaintiff begs to submit as follows. Then we go into the facts of the case. Facts of the case should be in the first few paragraphs. What was the relationship between the parties, and what was it a money transaction, or what was there any kind of lease deed they have entered into? Whatever it is, it has to be mentioned briefly, not briefly, it has to be mentioned in detail here. It has to be mentioned in detail, and all the dates should be specifically mentioned. You will, like as I stated earlier, if there is any error but which is very important, you can later on amend and add it to the plaint as well. But make sure while you present a plaint in the first instance itself, all the details are mentioned properly. Clear? So so in the outline, there is, with regard to the fact, we have to establish who all are the parties, what was the transaction, and what was the breach the other person has done, and when and where was the cause of action. That is very important. Cause of action is very important. I'm repeating again and again. Cause of action, when the suit, that is the when in order to know whether it is barred by limitation or not, and also whether the court has right to try the suit or not, whether it has a right jurisdiction to try the suit or not, it is necessary for mentioning the cause of action. Then valuation is also very important. By same thing, whether this court has pecuniary jurisdiction or not, whether if it goes beyond 10 lakhs, it has to be filed before the subcourt. And accordingly, the court, why we mention the valuation is because you have to file a court fee. Have you learned about the Court Fees Act? Court fees? No, right? There will be court fees and suit valuation act is there. Accordingly, for each and every suit, different types of valuation is there. For example, if it is in an injunction, I don't know about the Andhra Pradesh rule. I'll check and I'll tell you. For example, in Kerala, if it is Kerala Suit Valuation Act is there, and under Section 7 of that, for every rupees, one to for the first 10 rupees, for the first 100 rupees, 8 rupees should be the court fees. Like that way, it is one table of it is written. So likewise, for every suit, so much should be paid for the court fees. And at the time of filing of the suit, 1/10 of the money is need to be paid. Later on, it has to be paid. That is one PTS trial will be given. That is trial before the trial begins, you have to pay the court fees as well. Okay, so while instituting the suit, it is enough that 1/10 of the valuation has to be paid. So after cause of action, you need to mention the valuation of the suit. Then comes the grounds or the reliefs or the prayers that you ask for. What all are the reliefs that you want, whether it is an injunction or it is a prohibitory or mandatory injunction, or whether it is a suit for money. Additional reliefs should also be asked for. If it is for a money suit, if there is no payment of money is not be given, then can ask for alternate relief also. What would be the alternate relief in money suit? It could be an attachment. And while attachment also, what you have to make sure, you should give the correct schedule of the property which you want to attach. That has also to be mentioned. If there is a property or if it is a movable as well as immovable property, schedule has also to be there. You know the format of a schedule. If it is a property, and that property, if you want to attach that property, then you have to give a description. Why? Because the court cannot directly go and attach or anything. You wanted to locate the property. So in order to locate, how will we locate the property? What is the boundaries? First thing is, in which district it is situated, which taluk or which village or whatever, where the property is situated. Then in which survey number or in which block number the property is. Then the boundaries, east, west, north, south, in which boundaries it has been bounded by which properties. Then it will be easy for the people or the surveyors or whoever who is attaching the property, will be easy for them to locate it. If it is the number of the survey stone, whatever it is, all the detail has to be mentioned. So while attaching the property or any other things which is linked to a property, the schedule must be mentioned in the plane. That should be separately mentioned, not along with the plane. Like that, after the prayer or anything, a separate attachment annexure to the plane has to be there with regard to the schedule of the property. And in prayer also, all the prayers, all the reliefs that you wanted must be mentioned, along with alternative reliefs which the court may deems fit. That also has to be mentioned, and the valuation and whatever schedule is there, it has to be given. Now, what is the last step that you have? I have already taken in the other class. This is just the format of the plaint. Okay. Now the plaint is drafted, done. Now what we have to do? Exactly, very good. It has to be verified by one or any of the parties to the plaint, and this the signature of the advocate must also be there. This is, and one more thing, one important thing is, you might be relying on a specified document or a number of documents for in support of your claim. All those documents original has to be produced while you are filing the plaint, or at least before the trial begins. Because that is why pre-trial steps, one posting will be given in all the courts. Pre-trial steps, that is before the trial begins, some steps has to be taken. That is, if there is any new documents at the time of institution of the plaint, you might not have the documents. Later on, you might get it. So those documents has to be produced. If there is, maybe at the time of filing the plaint, you produced a photocopy or an attested copy, which cannot be taken record. You have learned in evidence, right? Secondary evidence. So you have to file the original before the trial begins. So those are the steps, including the notice that you have sent. It is also a document. Understood? Including the document has to be given before the court. So this is the gist of the plaint. So while drafting the plaint, what all things you have to keep in mind? The parties to the suit. First, whether the court has jurisdiction, in which court we are gonna file this. Whether it is if the valuation goes beyond 10 lakh, it is the higher court, and if it is below 10 lakh, up to 10 lakhs, it is the lower court. Okay, then make sure you add all the reliefs, all the claims that you want to ask for, because further on you will not be allowed to add on the grievances. So make sure you do add on all the reliefs you want to ask for, and joinder of parties is also important. Joinder of causes of action is also important. So far, is it clear? Is it clear? Any doubt? Done. So that is for today, and tomorrow we'll get the learn about the return statement. So please learn order 2, order 7, 6 and 7 before starting this. Okay, before drafting this, order 2, that's for a idea. Then order 6 and order 7 is very important with regard to the plate. Now, so far is it clear? Now for another important announcement, around 40 teams have given names for the Moot Court competition. So by 25th is the last, that is today's 20th. By 25th is the last date to give your names for participation. Okay. Whether you are willing to continue, or you want to withdraw, whatever it is, by 25th of this month, give me your names, and by April 1st, you need to submit the soft copy of both the memorials. Okay, soft copy of the memorials has to be given by April 1st, and by April 25th, you have to give your names, final names, those who wanted to participate or not. Then, after giving your names, and later on, if you withdraw, or later on, if you come and say you don't want to participate, then those marks will be reflected on your Viva. So contestants, make sure if you really wanted to compete in this competition, give your names, and later on don't come to me that it is finding difficult or anything, you're not able to participate. Is it clear? Other regulations are tomorrow. Sir. The regulations are kept. Thank you, students.
Let's go.
Okay. It's okay. It's very good. So we were discussing. Good morning, please. Good morning. We were discussing on right of advocates to practice. Right to practice. We have seen right to practice is vested only on advocates. Under section 29, we have seen 30, subject to the provisions of section 34 of the High Court to frame rules, etc. We have seen. We have discussed on certain cases, case laws also. We have also seen in Venkana versus Mysore High Court that if an advocate is appearing before the court for his own personal matter, he is not allowed to use his robes and present as an advocate. And therefore, rights of an advocate includes right to practice of an advocate includes various other rights, duties which also he has to perform while performing his profession. One is nothing other than these rights are enveloped along with the other rights whereby he has to discharge his professional conduct by, say, for example, providing counsel to his client, providing counsel to his client. Client ke counseling കൊടുക്കണം. That is also a duty of an advocate. Then giving legal opinion, making drafting all the documents, instruments, pleadings before the court, affidavit also, making affidavit drafting includes all sorts of things, and other all documents which are included whereby he is discharging his professional conduct, participating in conference involving law, etc. are also the role which are played by advocates when they are performing their professional duties. So till here it is very clear. Till here it is very clear that right to practice of an advocate is a statutory right given to advocates alone. These are rights which are given to advocates alone, not on a case law. N.K. Bajpai versus Union of India. N.K. Bajpai versus Union of India, 2012. 2012 for SCC 653. N.K. Bajpai versus Union of India, right? Capital UOI, Union of India. 2012 in 2014, 2012 in bracket, volume 4, SCC Supreme Court cases 653. 653. No? Okay, now in this case, in this particular case, it has been held by the Supreme Court that their reading of sections, which we have already earlier covered, 29, 30 and 33 of the Advocates Act 1961, clearly shows that right to practice is a statutory right vested only on advocates alone, which means advocates alone are the only people who can practice law, whatever court, before a person, before a tribunal, before any court, etc. Now, these rights does not mean that they are absolute, that my right is involved to practice and I am not being regulated by any authority. No, it is not so. We have seen that section 30 is again subject to section 34, power of the High Court to make rules. So there are courts can also, or courts also have the supervisory authority or power to supervise the conduct of a advocate. Now, that does not mean that there is another provisions under section 36 whereby an advocate can be punished for professional misconduct, proceedings of professional misconduct under section 36. This section is not the same with that what we can see in section 34 of the power conferred to the High Court to regulate certain laws, to make certain laws. So, Advocates Act 1961 by the provisions of the section 29, 30 and 33, it is very clear this is a statutory right given to advocates to practice, and also comes within the purview of Article 119 clause 1 clause G of the Indian Constitution, which makes it again a fundamental right to an advocate to practice. So this question will be arising in your part B question. Part B question paper, external question paper, that right to practice is coming within the purview of a fundamental right envisaged under which article? Right to practice is given to whom? Is it the private persons can practice, etc., or individuals can practice law, etc., may be asked. So this control over advocates are seen under section 34. Again, section 34 and also section 36. But the section 36 provision is disciplinary provision. Okay, it is disciplinary provision taken against an advocate, which we will come across later classes. Now, let us to the question of private person. Can any private person other than advocates practice law is a question. So, in which we need to refer to section 32 of the Advocates Act. Section 32 of the Advocates Act. Please refer to section 32. If I may read section 32. Power of court to permit appearance in particular cases. Power of court to permit appearance in particular cases. It is not talking about advocates. It is not talking about any particular person also. Let us see. Section 32 is read as follows. Notwithstanding anything contained in this chapter, any court, authority, or person may permit any person, it's not speaking about advocates, any person not enrolled as an advocate under the Advocates Act to appear before the court, before that person, before that authority in any particular case. So that court, that authority, that person before whom that particular case is being entertained may, it is not shall, may allow any private person to appear on behalf of anybody. I am not talking about the individual himself appearing for his own case. I am talking about I am representing somebody else. Who is he? Is he an advocate enrolled under the state role? No. Section 32 is not referring to any advocate. It is referring to any particular other individual. He himself is not appearing, but I am representing any other person on behalf of me. Now it is the court's discretion. What is the word used here? It is the court, any court authority may allow. So it is a may presumption. It is the authority of the court to decide whether or not to allow any particular individual to appear on behalf of anybody else. Please note down Harishankar Rastogi. Harishankar Rastogi. R-A-S-T-O-G-I. Harishankar Rastogi versus Harishankar Rastogi versus Giridhari Sharma. Giridhari Sharma. Giridhari Sharma. 1978, Volume 2, Supreme Court Cases, 165. 165. Now, this is this particular case. Should I repeat the citation again? So this is a particular case where it was decided with regarding to right of a private person to appear. Right of a private person to appear on behalf of another individual. So we have seen still now section 29, section 30 and 33 also providing the provisions of the Indian Constitution, Article 19, 1 clause G also states that statutory provision which is providing under the Advocates Act of 1961 gives authority only to the advocates to appear and practice before any court, authority, tribunal, person, etc. But the section 32 also provides a provisions whereby, notwithstanding anything, it is starting with a non-obstinate clause. If you have studied interpretation of statute, you will know the section starts with a non-obstinate clause, which is none other than notwithstanding anything contained in this chapter. Any court authority person may permit, again, may presumption. So the authority vested upon that particular court before whom you are appearing, that particular person or that particular authority will have the discretion to allow any private individual to appear. In this case, it was held that any private person cannot seek representation or represent any party as of a right. So the may presumption is reflected herein. This may presumption which is there in the section 32 is reflected in this case, which means that you don't have a right, as of a right, you don't have any right to claim that I will represent for another person. Who are you? I am a private individual. I am not an advocate enrolled under the State Bar Council. So I am not any advocate, but being a private individual, on the basis of being a private individual, solely because I am being represented by the client. The client is giving me authority to represent for him. That does not mean that as of a right, I can appear on behalf of him. Why? Because it is the discretion of the court to allow it. The court may or may not allow. So, except I can be representing another, except if it is being permitted by the court concerned, for which I have to move a motion before the court. Or a memo. I need to give a memo before the particular court. I need to give a memo before the particular court, seeking for the permission of the court to represent for the client, whereby the client has given authorization for me to appear for him to represent my client. Maybe the client itself, maybe the litigant itself. Okay, so unless until such motion is being made, there are likely chances that the court will not allow. And even despite I am making a motion, it is upon the court to decide the matter. The court may grant or withhold such memo made. Okay, such a motion made by the private individual may be granted, may be withholded. Now this permission may be either cancelled also. Say, what if the court is in the first instance allows? The court in the first instance allows him, that is the private individual under section 32 of the Advocates Act of 1961, to allow to represent for a litigant. Then further the court finds it that that particular individual is consuming the valuable time of the court as he being unworthy. He is not worthy to represent another individual. He is consuming the time of the court itself and delaying the matter whenever, because the individual may not be aware of the procedure of the court. In such cases, what happens is that the court may again cancel such a permission given to that private individual under section 32 of the Advocates Act. However, this choice of an individual to represent, what if it is a case of representing himself? Then is it coming within the purview of this particular section? No. Till now, under section 32, we were discussing about a individual who is not representing his own case. അവന്റെ കേസ് അല്ല റെപ്രസെന്റ് ചെയ്യുന്നത്. He is not representing his own case. He is representing the case of another individual, another litigant, where the other litigant is giving an authorization to the individual who is not an advocate, Now herein, whereby on the other case, that is cases where it is been he is representing himself, an individual is representing himself, I am representing myself. In such case, in a dispute before the court or tribunal, it is an inherent right. Note it down. It is an inherent right. Whereas on the other case, it is not a right. As of a right, I cannot claim. When I am representing somebody else, who is an individual, not an advocate, I have no right to claim that I need to represent. It is total discretion of the court, kacheri. It is. Oh. Yeah. No. It's not. It is not. It is infringing the right of an advocate. No. That is why specifically under section 32 it says so. That confusion which you have is being clarified under section 32 and in the case which we have, Rasdogi's case, which we have written. Which means that even though it is a statutory right of an advocate to practice law, he is not there by it is being represented to an individual. It is being given, a representation is given to an individual. He is taking away the right of an advocate to do his profession. That is your doubt. It will not conflict, because generally what happens is that the court will never allow such things, because it is the capability of that particular individual himself. Court will always allow you to represent your own case. Why? That is because it is your inherent right. Now that is also conflicting the interest of the professionals. Why not? Yes, it is your fundamental right. Now that is not a fundamental right. That is why it is may presumption added on to 32. It is the authority of the court to decide. But generally what happens, even though that is in conflict with each other, that is what it is clearly provided in 1978 case, that even though it is being given, it is not in conflict with the interest of the counsels, the advocates who have enrolled themselves. That will never happen, because it is interest of an individual, my individual interest, that I am not believing in the lawyers society. I don't have any belief in advocates. I'm giving you an example. Say a person doesn't believe in advocates, but he believes in one particular person whom he entrusts his case, and he believes that he can successfully represent his interest. But provided this can be protected only if the court allows. And that is not in conflict with the provisions of the statutory rights which is acquired by the advocate, which is made clear in this particular case also. You go through the case, your doubt will be cleared. Okay, now, however, as I told you, it is an inherent right of a person who is an individual who is representing his own case. What do you mean by inherent right? Acquired by birth, now which cannot be taken away also. So it is only the privilege to represent through somebody else, but whereas other, it is an inherent right. Okay, again, another case, India Yamaha Motors Private Limited, India Yamaha Motors Private Limited versus Dharma Singh, Shine GH, 2015, volume 2, 2015 in bracket, volume 2, Supreme Court cases, that is SCC 108. Please refer to the case. There are many cases where which are good examples, where a person representing himself If you go to High Court, if you go to several courts also, you may come across these cases. Good example would be, again, Subramania Swami's case, where he has filed a case against the Shashi Tharoor for the murder of his wife. What was his wife's name? Sunanda Puskar. Sunanda Puskar. Now let us come back to Advocates Act of 1961, which is containing how many sections? 60 section. Etra chapter? 7 chapter. Act citation 25 of 1961. Now we have gone through the certain provisions of Bar Council of India, Chairman of Bar Council of India, Chairman of State Bar Council. Now section 3 of the Advocates Act again reflects State Bar Council. Note it down, section 3, State Bar Council. What do you mean? The establishment of State Bar Council and then establishment of State Bar Council. Each state will have its own bar council. Each state will have its own bar council. Now the State Bar Council with its own electoral body members not exceeding, not it down, a small calculation. If it is not exceeding 5,000, its members would be proportional representation. Its members would be not more than 15 members. If it is not more than 5,000, it is not exceeding 5,000 is equal to 15 members. There will be 15 members. If a State Bar Council, its electorates are not exceeding 5,000 is equal to, there will be 15 members. Now, if it is not exceeding 10,000 but exceeding 5,000 but less than 10,000, then is equal to number of members would be 20 members. 20 member. Okay. Now, if it is exceeding more than 10,000, the number of representation would be 25. Up 15, 20, 25. 5,000, 10,000, again, okay, more than 10,000. Now, each advocates who are enrolled in their role, respective roles of the state. Where are you going to enroll? Tamil Nadu. Where maybe others may be enrolling in Kerala, Andhra Pradesh, under their respective state bar councils. So your name will be there in the respective state roles. Okay. So an advocate who is enrolling in your respective state bar councils will have a single vote to elect those representatives, 15, 20, 25. You are going to elect them, elect the members of the State Bar Council. You will have single vote. You will have single vote to elect on the basis of proportional representation. On the basis of your proportional representation. Depending on the number. If it is 5,000, it will be 15. If it is exceeding 5,000, less than 10,000, it will be 20. If it is more than 10,000, it will be 25. Okay, likewise. Now the term of the elected members would be 5 years. Refer to section 8 of the Act. Section 8 of the Act. Yeah, section 8 of the Act. Term of the office of members of the State Bar Council. Section 8 of the Act. Now, any elected members as elected in accordance by the advocate who is electing them, as you all have single voter, I be once elected, I may be disqualified from being continuing as a member. Okay, I may be disqualified on the basis of, say for example, I was absent. I being the member of the State Bar Council, I was absent for the consecutive 3 times in the meeting. If I was absent for the consecutive 3 times in the meeting, that becomes a disqualification for on my side. My name again has been removed from the role which is maintained by State Bar Council. Again, I may be, that also becomes a disqualification or any other disqualification which are prescribed by the rules made by the state bar councils, Bar Council of India rules, etc. That all becomes a disqualification on my side to be continue as a so not as an advocate, as a member, whereby I have been elected as a member in accordance to section 3. Now 8 is the term. Now let us see certain the section 6. That is the functions of bar council, state bar council. Functions of state bar council. If you come across section 6, you need to go to section 6 clause 1. Functions of the state bar council. The functions of the state bar council shall be A, B, C, D, double D, E, double E, triple E, F, G, and double G. These are the functions. Please go through the act itself. I am just going through the act. First, A, to admit person as advocate on its roll. So again, whenever I am enrolling myself, my name will be entered in the roll which is maintained by the State Bar Council. That is also a function which is performed under section 6 of the Advocates Act. Now, second, that is B, to prepare and maintain such roll. This roll shall be prepared, shall be maintained by the State Bar Council. Now, to entertain and determine cases of misconduct against advocate on its roll. So again, whenever there is a professional misconduct done by that particular person, who will take action? Say you have enrolled yourself in Andhra Pradesh and for your professional misconduct, it is not a complaint given to the Bar Council of Kerala. Because the concerned authority to take action against you is Andhra Pradesh. Andhra Pradesh State Bar Council. So the concerned State Bar Council has to determine the cases of misconduct against a particular person whose name is there in their roll. D, to safeguard the rights, privilege, and interest of advocates. The interest of an advocate, the rights of an advocate, the privileges of an advocate shall be protected. So again, it is a duty of the State Bar Council to protect the interest of those advocates' interests, privileges, and rights whose name again entered in their rule. D. Now let us see DD and DE. Please go through those sections. I don't want to repeat those sections. Now, before going to the Bar Council of India, let us see. I actually forgot to take this topic. Who may be admitted in the roll? State roll. Who may be admitted in your roll? What is your qualification to get yourself enrolled? You all know what your qualification is. What is your qualifications? What are your qualifications? Take yourself. I am an Indian. First. What is my age factor? My age would be above 21 years. I have completed 21 vayas, 21 years. So take yourself as an example. Then I have a diploma in law. I have a diploma in law, distance education diploma in law. So that becomes a qualification to enroll yourself as an advocate, diploma in law. You are nabbing your head, so I thought it is also correct. Diploma in law illa. You have to have a degree in law from where? An unrecognized university. Anywhere, Kundangalam University. No, it is not so. You need to have from a recognized university. You need to have a degree in law. Isn't it so? So these are all the qualifications possessed by a person to get enrolled in the state roll. So he should be a citizen of India. Now the question arises, provided a national of another country may be admitted in the state roll to enroll himself as an advocate. May be allowed to enroll in the allowed to enroll in the state roll if he is duly qualified and permitted in accordance to the law that is existing in India. Again, I told you, refer to section 47 of the Advocates Act. Please refer, note it down. Section 47 of the Advocates Act. Reciprocity. Okay. Reciprocity. It is titled Reciprocity 1. Where I'm reading this section, it is read as follows. Where any court, comma, specified, sorry, where any country, comma, specified by the central government in this behalf by notification in the official gazette, comma, prevents citizen of India from practicing the profession of law or subjects them to unfair discrimination in that country, comma, no subject of any such country shall be entitled to practice profession of law in India. Is it clear? So any particular country, say for example, a country named America, I'm giving you just an example. United States of America or an X country. In X country makes a circular but through a government gazette, or they have a rule stating that Indians cannot practice here. Indians cannot practice law in X country. And or there are certain discriminative practices in X country where they are discriminating Indians to practice law. In such cases, members of X country, that is citizens of X country, will not be allowed to practice in India. If you are treating us wrong there, we will treat you guys wrong here. Okay. Is there any status? Maybe there are plenty of countries where you cannot. Say for example, Saudi Arabia. Can you practice law there? Can you argue law there? No, you cannot. They should be Saudi citizens. You cannot. You can go and work as paralegal officers there. Paralegal officers I work here. You can be clerk. London also he practiced law. That is why reciprocity basis they may be allowed. But I am talking about, he was asking the question where you cannot practice. You cannot practice in Saudi Arabia. They cannot practice herein also. Because we are not allowed to practice that, they are not allowed to practice herein. The second paragraph of the reciprocity section is section 47. Subject to the provisions of subsection 1, Bar Council of India may prescribe certain conditions if any subject to which foreign qualification in law obtained by persons other than Indian citizens shall be recognized for the purpose of admission as an advocate under this act. Now the question arises, what if your friend has taken a law degree from another country? Who is he? He is an Indian. What is his age? He is 21 years. Where has he completed his degree from? He has completed it from Switzerland. Now the question is, can he enroll herein? Provided if that particular degree is accepted in India by the Indian law, by the UGC, or sorry, by the Bar Council again, you are allowed to enroll in India as an advocate. Now, as I told you, law degree, there are disqualifications also. There are disqualifications also which disqualifies you from enrolling as an advocate. Say for example, no person shall be admitted as an advocate under section 24 capital A. Note it down, disqualification. Section 24 capital A, disqualification. When he is convicted for an offense which is involving moral turpitude. Now the definition of moral turpitude can be interpreted from cases to cases. Okay. From moral turpitude, he has been involved in an offense where he was convicted, not an accused. He is convicted for an offense which is involving moral turpitude. One. Again, he is convicted for offense which is involving the provisions of Untouchability Offences Act 1955. Convicted for an offense under any sections of the Untouchability bracket open offences bracket close Act 1955. 3. He has been dismissed, removed from any employment. That is employment under the state government. Again, he was dismissed, he was removed from state government employment for the purpose whereby he was involved in an offense involving moral turpitude again. Third, then these three qualifications, if it is exceeding after conviction 2 years, this disqualification shall not be considered. Okay, after conviction, after you have been convicted and you have undergone the imprisonment, 2 years have elapsed after that, this disqualification will not become a disqualification. It has elapsed after 2 years. It is considered to be as a punishment period where you have completed it. Mahipal Singh Rana versus state of Uttar Pradesh. Mahipal Singh Rana versus state of Uttar Pradesh. Mahipal Singh Rana, Mahipal Singh Rana, S-I-N-G-H, Rana versus state of UP, Uttar Pradesh, open bracket, 2016, 2016, close bracket, 8, volume 8, Supreme Court cases, SCC, page number 335. Please note it down one sentence. It was held that disqualification from enrollment under section, under which section? 24 capital A, 24 capital A, at the entry level, as well as post enrollment level. Okay, at the entry level as well as post enrollment level. So you yourself enroll as an advocate. Say for example, you got your LLB degree from an unrecognized university. You enrolled yourself. Somehow you maintained yourself, manage yourself to intrude yourself into the role of the state bar council. Are you safe? No. If a complaint is received against you regarding your recognition, the recognition of your degree, there are every chances that you will be dragged down from the role of the state. Okay, thank you. It's already 11:07. You may have a break. No, what? Please. Break. Break. 11:15. आएंगे. जाना तो पड़ेगा, आना तो पड़ेगा.
Please settle down. Is it audible? Please settle down. Please listen. Once you come into the class, listen something. With you, something. Please. So till now, we have seen what is meant by arbitration, what is meant by conciliation, what are the different kinds of alternate dispute resolution. Yes, different forms of alternate dispute resolution. So, two acts which is our arbitration and conciliation in India. Yesterday we have seen how to enter into last place. Different forms of how we have different modes of entering into arbitration agreements. One is arbitration clause, second one is submission agreement. Now, now these are the two ways in which you can enter into an arbitration agreement. Now you have entered into arbitration agreements. Now you want to appoint arbitrator. Right. Now, yeah, please. Now you are going for, here two things will happen. When you are not listening, you are not up to the mark. உங்களுக்கு புரியலன்னா it's helpless at the fag end of your things. Please listen. Right. Now you are going in appointing an arbitrator and you are determining the jurisdiction of arbitrators. Right. Now jurisdiction normally in contracts, that is determined by the legislation. In normal contracts, jurisdiction determined by legislation. Here the jurisdiction of the arbitrator is determined by the consent of the parties. Consent of the parties here. Now you want to go for arbitration. Two things will be there. In the arbitration agreement, which forms part of the main contract or which forms part of the collateral contract, you can mention and determine the appointment of arbitrators. Right. Here, you want to go for arbitration. You may mention in the contract, if we have disputes, we will go for arbitration. That means you are not determining the arbitrator yet. Only on arousal of the dispute, you are determining the arbitration. Second one is, if we have disputes, we will go and approach ICC. That is, institutional arbitration centers you can go and approach. You are free to decide the appointment of the arbitrator. Again, you are free to decide which institution will determine the appointment of arbitrators. Now, section 10 of the Arbitration Conciliation Act says, section 10. Please listen. Hearing is your fundamental right. Not hearing is also your fundamental right. நீங்க கேட்டா உங்க fundamental right, கேட்கலனாலும் that is your fundamental right, but subject to reasonable restrictions. புரிஞ்சுதா? Please listen. Once if you come into the class, take with you something. You are spending such a huge amount and coming over here. Listen something at least this 10 days. இத்தனை நாள் எப்போ கிளாஸுக்கு வரல, ஒரு 10 நாள் வந்தா ஏதாவது மைண்ட்ல போகும். புரிஞ்சுதா? Right. Now section 10 speaks about appointment of arbitrators. What this section speaks about is, the parties are free to determine the appointment of arbitrators, provided such a number shall not be an even number. You can appoint any arbitrator, any number of arbitrators, but it cannot be an even number. Even number என்ன? 2, 4, 6, 8 appoint பண்ணக்கூடாது. You can appoint. This is first aspect. Second aspect, even this section speaks about, you can appoint arbitrator of any person belongs to any nationality. You can appoint any person of any nationality you can appoint. That means he need not be an Indian citizen. Any person, any national, he can be appointed as an arbitrator. But normally, you know, again the arbitration are governed not by rigid requirements of the law. That means CPC don't apply, Evidence Act don't apply, normal laws won't apply to arbitration. Purely arbitration is governed by rule of what is called principles of natural justice. Rule of equity will apply. Principles of natural justice, that is, you know, notice and hearing only apply. So you know, now the arbitrator is going to be appointed, but it is better if you appoint a person who have experience in the field of law. Why? He can make a better adjudication of the disputes. Now, after this Arbitration Conciliation Act 1996, one amendment act has come into picture, that is Arbitration Conciliation Amendment Act 2019. Previously, there is no prescribed qualification for appointment of an auditor, except it should not be an even number. Any person can be appointed, any nationality can be appointed as an arbitrator. Now this act speaks, any advocate who is having not less than 10 years of experience. Any advocate having not less than 10 years of experience can be appointed as an arbitrator. Then any chartered accountant not having 10 years of experience, he should be a member in the Institute of Chartered Accountants of India. Right. Any cost and management accountant having not less than 10 years of experience and who is a member in the Institute of Cost and Management Accountants of India. Then any company secretary who is not having less than 10 years of experience and who is a member in the Institute of Company Secretaries of India and any member who serves in ILS, Indian Legal Service also. Now, certain qualifications has been prescribed under the new Amendment Act 2019. Right. Now, you have appointed the arbitrators. Right. Now, arbitrator is nothing but he may be a sole arbitrator or arbitral tribunal. You understand? Arbitration includes, arbitral tribunal includes sole arbitrator also. That means one arbitrator is also called as an arbitral tribunal, 2, 3, whatever it may be, they are also known as arbitral tribunal. Now, you have appointed the arbitrator. Now, once how he is appointed? By your consent he has been appointed. That is, by the free will of the parties, arbitrator has been appointed. Now, he is sitting in the chair for adjudication of your disputes. Remember, now, once he sits in the chair, he has certain things. For example, you file a civil suit. You file a civil suit. If civil suit does not disclose jurisdiction, what happens to your suit? You understand my question? You understand my question? நீ ஒரு கோர்ட்டுக்கு போன, family court இருக்கு. Family court என்ன jurisdiction இருக்கு? Only family disputes it can adjudicate. You went to civil courts, civil suits. That is the jurisdiction. That is the jurisdiction. For example, you filed a suit for injunction in family court. You understand? You filed a suit for injunction family court. Whether family court has jurisdiction over your suit? No. Then what happens? The suit will be, yes, rejected or dismissed. No jurisdiction. Here also, arbitrator has been appointed by the free consent of the parties. Then at any point of time, but before filing of statement of defense. You understand? Arbitration la first enna file pandra number? Statement of claims and statement of defense. Before filing the statement of defense, you have to raise the objection with respect to jurisdiction. You understand? Before filing the statement of defense, you have to raise the objection with respect to jurisdiction. You understand? Now, you have not raised the jurisdiction. You have an obligation to speak. You have not spoke. Then what is the rule? Rule of? Very good, estoppel. Estoppel. Enna estoppel anna? Shut your mouth. எதெல்லாம் வந்தது இந்த ரெண்டு எஸ்டோப்பல் மேல ரெண்டு क्वेश्चन வந்தது உங்க எக்ஸாம்ல. என்ன சப்ஜெக்ட்ல? எவிடன்ஸ் ஆக்ட். என்ன எஸ்டோப்பல் கேஸ்ல வந்தது? ப்ராமிசரி. யா, ஸ்டூடெண்ட்ஸ் who heard my class they know. என்ன ப்ராமிசரி எஸ்டோப்பல் அண்ணா? அது ஏதோ ஒரு டைப் ஆஃப் எஸ்டோப்பல் சார். அது என்ன எஸ்டோப்பல் தெரியாது எங்களுக்கு. ரைட்? இட்ஸ் ஒன் ஆஃப் சம் டைப் ஆஃப் எஸ்டோப்பல். I don't know. Equitable estoppel, promissory estoppel, estoppel by record, estoppel by conduct, estoppel by silence. அது ஏதோ ஒன்று வரும். Right? Here, you have not raised it with respect to jurisdiction. Subsequently, award has been passed. Now, whether you can raise the plea of jurisdiction at this stage? No. Award can be challenged on any other ground except on the ground of jurisdiction. You understand? It operates as a estoppel. Right. Now, first power of the tribunal is it will determine its own jurisdiction. First aspect. Again, why I am telling you is this jurisdiction is determined by the consent of the parties, not by any legislation. You remember. It's determined by the consent of the parties, not by any legislation. So, if you have any dispute with respect to the jurisdiction of the tribunal, it should be raised even before filing the statement of defense and not later. If you want to challenge the same on the respect of jurisdiction, it operates as an estoppel. You cannot challenge the same on the grounds of jurisdiction, but subsequently it can be challenged on any other limited grounds under section 34 of Arbitration Conciliation Act. ఈ ఒక్క గ్రౌండ్ పైన మీరు ఛాలెంజ్ చేయడానికి కుదరదు. Right. First important function of this is to determine its own jurisdiction respect of the dispute, arbitration tribunal. Second one, next one is they have to determine the procedural rules with respect to adjudication of the dispute. Procedural rules. What is the procedure they are going to follow while adjudicating the dispute? ఏమేం procedures follow కావాలి? You know why this question arises? Why this question arises? They are not bound by CPC. They are not by Evidence Act. They are not bound by any law. Without following these types of laws, how and by following which procedure they are going to adjudicate your dispute? They have to mention the procedures by which they are going to follow the procedure. Right. What is the procedural requirements which they are going to follow while adjudicating your dispute? This is the second thing they have to determine after the appointment of this arbitral tribunal. First one is jurisdiction. Second one is applicable laws. Third one is they have to determine the seat and venue of the arbitral proceedings. You may enter into contract in Hyderabad, but if you want to determine the disputes in Tirupati, it should be invariably mentioned in the arbitration agreement. They are going to determine the seat and the venue. They may enter into contract with arbitration agreement in London to sit in India. Inga vanda ninga arbitration panla anna panla. With respect to disputes arose in the London. So you have determined the seat and venue of the arbitration agreement. This may be in respect of convenience of the parties. Convenience of the parties, you may determine the seat and venue of arbitral proceedings. Next one is it have determined the language of the arbitration. Fourth aspect is you have determined the language of the arbitration. How the statement of claim has to be filed in which language, statement of defense has to be filed in which language, how the award is going to be passed, everything you have to determine in advance itself. So this is the language at which you are going to conclude the proceedings of the arbitration. Right. Next one is what are the specific documents you are going to examine along with expert opinions also. Why? Arbitrator is not expert in every kind of law. He may appoint an expert with respect to any arbitral proceedings. We learnt about expert opinion in Evidence Act. Once the expert gives his opinion and that has been accepted by the arbitral tribunal. That is the opinion of the arbitral tribunal but not the expert. You understand? Once expert comes and gives his opinion, that opinion has been acted upon by the arbitral tribunal. That opinion does not become opinion of the expert in law, that becomes opinion of the arbitration tribunal. Okasari vaadu accept chesin tarvata expert role is gone. Only now it is opinion of the arbitral tribunal. Next one is provision of interim measures. Provision of interim measures. Yesterday, I have spoken about interim measures taken. If you remember and recapitulate, what are the interim measures? Appointment of a receiver, appointment of a guardian for a minor, so on and so forth. Whether interim measures will be allowed or not under section 17 of Arbitration and Conciliation Act. What is meant by interim measure? Enna interim measure anna? Interlocutory applications, interlocutory orders. What is? It is nothing but even before the final adjudication, certain applications has been made and on that application order has been made. Interlocutory application. IML order kuduta adala interim measures. Again, if interim measures has been made applicable to these proceedings or not, that has to be specifically mentioned under section 17. Next, passing of awards on termination of proceedings of the arbitral tribunal. So if you want to pass an award, how an award is going to be passed on the termination of arbitral tribunal. And last one is cost. Cost includes fees of arbitrator, legal fees and expenses, administration fees for the institution, fees and expenses of witnesses and arbitrators. Lastly, you have to mention what is the cost that has been to be imposed in the adjudication of these disputes. Right. Now you have clearly mentioned, you have clearly demarcated the role and responsibility to be played by the arbitrators. Now till you have not went before the arbitration, you are determining the jurisdiction, you are determining the area in which he has to operate by consent of the parties. Now arbitrator has sat in the chair. Now he has certain duties. Now the duties of the arbitrator can be divided in two ways. One is duties imposed by the parties. Second one is duties imposed by law. Duties imposed by the parties. Why? Arbitration is concluded nothing but free will of the parties. Now, duties imposed by law is also there. He has to follow two duties. One is determined by the parties. Another one is law imposes on you. For example, a construction project is there. Now, there is a dispute with respect to construction project. Now, they have entered into arbitration agreement, and in that agreement, they had one clause that arbitrator has not only to adjudicate this dispute, he has to visit the construction site at abroad also. For agreement, not only this he has to adjudicate the dispute, London and the construction site solli that means it is the duties imposed on the parties first. Second duties imposed by law is, arbitration agreement is not bound by procedural laws. Now it is bound by principles of natural justice. What is the principles of natural justice? Ad alteram partem. So he should adjudicate the dispute fairly and impartially. So duties can be bifurcated into two types. Duties imposed by the parties, duties imposed by the law. Right. You know, if you don't follow the principles of natural justice, and order is correct also, correct order is passed, but violation of principles of natural justice, order is vitiated in the eyes of the law, it is non-est in the eyes of the law. It is not recognized by the law. So this agreement itself imposes a duty of independence and impartiality. Duty of independence and impartiality. Now, one concept will come into this picture. You know, an administrative law, you have learnt about bias. Bias. What is meant by bias? Even before the adjudication, you are concluding and determining the justice. Again, if you have any bias with respect to any arbitrator, it has to be challenged even before submission of the final award. Here, different types of bias: personal bias, pecuniary bias, bias over subject to matter. என்னென்ன bias? Pecuniary bias, personal bias, bias over the subject matter. Now, coming into practical aspects now. Arbitrator is sitting. Right. Now, you have raised the plea of bias. Bias and என்னன்னா எனக்கு న్యాయం కడికాదు, నాకు న్యాయం జరగదు అని ఒక రైజ్ చేసావు. రైజ్ చేసినప్పుడు that is the first plea which has to be determined by the arbitrator even before going into merits of the case. You understand? நீங்க ஒரு கோர்ட்ல கேஸுக்கு போனோங்க. You have filed a writ petition in the High Court. You have got certain apprehensions with respect to the judge. What you are going to do? You are telling to the court, I don't find that I will get justice. That means what the court is going to do? He will come out of this case. Here also, you have raised the plea of bias before the arbitrator. Right. Now, arbitrator has two options. One, to step out from the arbitration. Step out from the arbitration, or they have ruled out your bias and going with the arbitration. You understand? They are not hearing your plea. One arbitrator says, yes, I will go out of the case. But another case, arbitrator is telling, I don't accept you. I am going to adjudicate your disputes. That means he is not determining your plea and straight away is passing an award. Subsequently, after passing of the award, we have to challenge the same for this plea of bias. You see, you know, in civil procedure code, appeals is there. Enna appeal anna? First appeal, second appeal, so many appeals is there. Appeal is not your inherent right. There is no appeal for every order. Only statute has to given that right to you. Appeal is not your inherent right. எல்லாத்துக்குமே அப்பீல் இருக்காது. அப்பீல் இருக்கணும்னா எங்க இருக்கணும்? அது அந்த சட்டத்துல இருக்கணும். அப்பதான் நீங்க அப்பீலுக்கு போக முடியும். For example, an order is an non-appealable order, then what you are going to do? அந்த ஆர்டருக்கு அப்பீல் கிடையாது. அப்பீல் கிடையாதுன்னு எதுல இருக்கு? சட்டத்துல இருக்கு. அப்ப எங்க போனோம்? ஜுடிஷியல் ரெவ்யூ. என்ன ஜுடிஷியல் ரெவ்யூ அண்ணா? Judicial review, nothing but writ petitions only under 32 and 226. If there is a non-appealable order, that does not mean that your grievance has not been redressed. You have to file an judicial review. Right. Now, two things will happen. One is getting out of the arbitral chair, or second one is going with this arbitral proceedings. Now, you know the concept of bias. Even there is a reasonable apprehension in the minds of the party that constitutes bias. Bias need not be in true nature. Bias undali undi nirupinchalsina pani ledu. You know, justice ought not to be done, seems to be done. Even there is a reasonable apprehension in your minds, that itself creates bias in the minds of the parties. ఒక reasonable apprehension ఉంది అనుకోండి. A reasonable apprehension means it is not based on cogent materials. If you want to prove the bias, how you are going to prove? By way of material evidence. There is no evidence. Even there is likelihood of misapprehension also. It creates bias in your mind. You understand? So, even if there is a bias, it can be challenged. So, different types of things which creates apprehension in the minds of the parties. That means, relationship of the arbitrator, first one is relationship of the arbitrator with respect to any of the parties. That arbitrator may be related to any of the parties. For example, one judge is there. A case comes before the judge pertaining to Reliance Industries. Reliance Industries. Now, judge's son is having shares in the Reliance Industries. Judge's son. Judge is not having. But even though judge is not having, judge's son is having shares in the Reliance Industries, that creates apprehension in the minds. So that creates apprehension. Whether the judge is very, very impartial also, but still it creates some sort of misapprehension in the minds of the parties. So the relationship of the arbitrator with respect to any of the parties likely to create misapprehension, bias. Second one is the arbitrator is performed as a lawyer, legal officer, or he has given legal consultation prior to the arbitration to that client. He may be a lawyer, legal consultant, whoever it may be. He has rendered certain services respect to that party in past. Third, the arbitrator has been an adjudicator in any matter him in the capacity of a judge previously. Previously he is an arbitrator in any capacity as a judge. Next one, fraudulent collusion. If there is a fraudulent collusion between the party and the arbitrator, it is likely to create misapprehension. Then, if the arbitrator was indebted to any of the parties, indebted anna party kitta kadan vaanginda, party kitta judge kitta kadan vaanginda, இந்த கேஸ் ஜட்ஜ் பண்ணக்கூடாது. ஜட்ஜு கிட்ட கடன் வாங்கலாமா? அவர் கொடுத்தா வாங்கலாம், அவர் கொடுத்தா வாங்கலாம். If judge gives money, you don't take. I will take money from judge. If he gives, I will take. என்ன துளசிடா? யார் இந்தியால ஃபேமஸ் லாயரா? Who is famous lawyer in India? Absolutely wrong. You are the famous lawyer. அந்த கான்பிடன்ஸ் இருக்கணும். யார் ஃபேமஸ் லாயர்னா நான் தான் சொல்லணும். அவன் எவரோ பேர் கொண்டு சொல்றாங்களே நீங்க. யூ ஆர் தி ஃபேமஸ் லாயர் இன் இந்தியா, நாட் ராம் ஜெத்தல்மானி, தட் ஜெத்தல்மானி. நான் நீ இப்ப கிளாஸே நீ கேட்கல, அப்புறம் ஆஃப்டர் என்ரோல்மெண்ட் என்ன திருப்பியா? நீ என் கிளாஸ்க்கே நீ ரெகுலரா வருதில்ல. ரைட். நோ திஸ் ஷுட் பி யுவர் கான்ஃபிடன்ஸ். யார் ஃபேமஸ் லாயர்னு என்ன சொல்லலாம்? நான் தான் சொல்லணும். ரைட். நவ் no they are in different mood. That's why I have given some satirical things. Life la and confidence irukano. There should be only one lawyer, that should be me. Naan da lawyer. Right. Next one. Arbitrator has rendered some legal service free of cost in the past to the parties. These are all the situations which creates a reasonable apprehension. Bias may not be a true bias. Even it creates a apprehension in the minds of the parties, then they have to step out from the arbitral tribunal. So these are the rules that are applicable to arbitral tribunal, duties of the arbitrator, and bias. We will see powers of the arbitrator and giving of award next class. Got something today? Right, good.
Hello.
Good afternoon, class. So today we are going to discuss about the organized crime. What is organized crime? When, yes, sir? When you have an organization and that organization has a plan which is properly executed to commit any act or omission which is contrary to law, is organized crime. Yes or no? So, organized crime is an antisocial act done by a group as a joint venture in a planned and in a systematically organized way. That is organized crimes. For example, we can say that 392 definition of documentary. What it is? 5 or more persons. So they create an organization to commit a crime of robbery, and it becomes a documentary. If we go to different jurists, that what is their opinion about the organized crime, as Dr. Walter He says, an organized crime is an unlawful misadventure which is carried by a boss, his lieutenants, and their operatives. That means there is someone in the top who is the dealer or who is the boss. He gives instructions to the second one, and the operatives, and then, or we can say, the persons. So we can say that someone gives the order or make a plan. Another one is there who control the operatives in the ground level. That means those who gives or the boss are behind the scene. The lieutenants, his lieutenants and the operatives are in the ground levels to execute that criminal activity. According to Dr. Walter Rackless, this is a organized crime. So similarly, many jurists gives the same definition in different ways, where they says there is a topmost person according to who create a plan, gives order, and there are some other persons who execute that plan. They are the operatives, and collectively that thing is known as organized crime. So what are the characteristics of organized crime, or when we can say that this crime is a organized crime? First, this organization consists of groups, basically unlawful assembly 141. Yes or no? Second, it is become a centralized organization. That means there is a hierarchy in these groups. Boss, then second in order, then the operatives. Highly centralized. The power, the giving the order, the power to give the order is centralized in one person or a few persons. Third, there is a sense of unity and oneness. That means the operatives or second in place, they follow the order of someone who is the boss. So, and the group which is formed in a centralized way, they create such a defense or to protect themselves. They create such a situations or organizationally they're so collective. It is too hard to penetrate into that organization. So these are some cases or characteristics of a organized groups where the criminals or crimes are happened. Now, what are the kinds or types of this organized crime? First, predatory crimes. Second, racketeering. Third, syndicate. And fourth one is political graft. Organized predatory crimes. Predatory crimes. Datory. Predatory. Predatory. Predatory crimes. Racketing. Simple racketing. 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 Or some says it racketeering. Racketeering. Rackettering. Then syndicate. Fourth one is political graft. Done? Politicals graft. 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 So, what is predatory crimes? When two person or more than two person involved in a crime because of their own benefit, like conspiracy. 120A definition IPC. What it says? Conspiracy. When two or more person have enter into an agreement to do an illegal act or to do an illegal act in a illegal means is a conspiracy. Yes or no? So in that conspiracy or in this agreement, both have might be same objective or might be different objective, but the utmost motive for the personal gain. I conspire with him. Today there is a transaction of money from RBI to this particular bank and we are going to rob it. This is our conspiracy and we both have a ulterior object for personal gain. We don't care about each other. If I get all money, I'll take it and leave the place. That is organized predatory crimes. You are only there with your personal intention or personal object to gain profit in a wrong way. That is predatory crimes. Now come to second one, racketing. I think you heard about that drug racket or human organs racketing. Yes or no? So racketing is rendering an organized manner illicit goods or service to the consumers who are generally in a legitimate activities. I am in this profession and I need some contraband things. To whom I shall contact? To these rackets, those who deal with the contraband things. I need opium, I need heroin, I need something. I contacted to them. So those who gives or provides service or gives certain things which is contrary to law are rackets. That means it is basically a organization who gives or who provides you the illicit goods, that are the rackets. So if we categorize these things or if we segregate these things, so we can find out what are the elements of this rackets. First, with the materialistic advancement of the society, the people wants to gain more, and for that gaining they create a organization or group. From first point to second point, to whom that group serve? To those peoples who lawfully cannot satisfy their wants. Now I need opium. Lawfully I cannot do that thing. Those groups helps me. Yes or no? Third, so to satisfy that need, these groups create the service providing system, or they advertise their things that we giving you this contraband things. So to satisfy that service, they implanted certain individual or group of person to fetch that thing and to deliver that thing. So these are the main characteristics of the racketing. In simple words, we can say that a person has some illegal needs, and to satisfy that needs, there are someone to help it. These two things are needed for racketing. Yes or no? Now, third one, syndicate. In common words, we know them underworld. So similar to that organized, or as we discussed in that organized crime, I told you that there is a boss, they have some lieutenants, and they have some operatives who do groundworks. Syndicate is that type of thing. So crime syndicate is a gang of criminals engaged in the business of providing some forbidden or to do some illegal acts to the for their benefits. Like in 90s, if you have remember, there are gang wars. Yes or no? You heard about that gang wars? So there is Chota Shakil, Dawood Ibrahim's, and they have their groups, own groups. Hafiz Ahmad. There are some gang leaders who want to take control over this Mumbai, or at that time Bombay. So what they did, they create a syndicate who has the powerful syndicate, and they have the control over Bombay. And once you have the control at that time, once you have the control over Bombay, you have control over whole India. That is the syndicate. Syndicate is nothing more than just an organization who do every type of illegal things. Might be providing drugs, might be kidnapping, might be murder, whatever it may be, it is done by them. That is syndicate. Last one, political graft. The politicians who used all these three category of people for their own benefit, that creates that becomes a political graft. That means a person who is in power, who is in political seat, where he has some power to deal with this, and for his own benefit, he use all these three things: predators, rackets, or syndicates. That is political graft. Nowadays also, if you have go through the news, they use some certain criminals, certain illegal groups to get their desire. Once they satisfy, they eliminate that group or criminals. Nowadays in Odisha, there is a person, Dhala brothers. So they some type of kingpin of Odisha underworld, and some political party used them to get their desired result, to get that tenders to get other things in their for their benefits. That are the political grafts. So these are the types of organized crime. One important organized crime which we still left: terrorism. What do you mean by terrorism? Yes, yes. The group or the organization who terrorize the society for their own political agenda is a terrorist. Jaish-e-Mohammed, Al-Qaeda, ISIS, Maoist. So they are the terrorist groups who, for their own political agenda, own purposes, they terrorize the society by means of bombing, mass killing, and any other type of suicide attacks, hijacking. So they are the terrorists. It is also comes under a organized crime. If we take example of Al-Qaeda, there is one head led, that person, that Osama bin Laden. There are some other persons who are carry forward his orders to the ground level workers, and they did the things. Take example of that 26th November Mumbai attack 2008. Someone is there in some place. They give order to this Kassab and his other group members, and they carry forward the attack in Mumbai. Terrorism. So I don't think that we have to discuss more about terrorism, because each and every day we are come to listen that things, and I know I hope that you know more about terrorism. Yes or no? No. No. Then read it. Now, how that terrorism group or organized criminals get funding for their this attack or their crimes. Important, how they get that money. But important business was narcotics, drugs. You heard, I think you should, you have heard these two words, golden crescent and golden triangle. Nobody. Golden crescent is a place, like here we told now that NH16 golden quadrupled. It connected to Mumbai to Chennai, Chennai to Kolkata, Kolkata to Delhi, Delhi to again Mumbai. So like golden crescent is a place which connected from Pakistan, Turkey, Afghanistan. It is the place. And another one is golden triangle, Thailand, Laos and Bhutan. So these two places are the core of this drug dealing or producing of the drugs, basically opium. Byproduct of opium is brown sugar. So as these two major part of the world or drug world is nearer to India, India is also affected by that. Not only India, whole world is affecting by these things. Drugs. So what is that drug? So a narcotic drug is an addictive drug such as opium that reduce, alter, reduce the pain, alter the mood and behavior, which is usually used to sleep or stupor. So whatever that things is used for this purpose is a drugs. Some drugs are legal, some drugs are illegal. Medicine is also come under the definition of drug because it reduces the pain. Yes, sir. Yes. Medicines are there too, which is used for your benefit. That are medicines. Still comes under the definition of drugs. But drugs has its own negative connotation, which is used for a illegal purpose. So basically, that word narcotics comes from a Latin word narcum, which means to sleep. So that's why that medicine or drugs or that substance which gives you a sleep becomes a narcotic or drugs. So as we have discussed that it is not only the problem of India but also whole world. So there is a UN convention in 1961 known as Single Convention 1961, which is happened in Manhattan, US. So in that convention 1961 Single Convention over drugs or narcotic substance, whole world together to give or to they have the togetherness to check the dealings of these drugs production and trafficking. As India is a part of this thing, so in 1985 India make his own law, NDPS Act, Narcotic Drugs and Psychotropic Substance Act, where they can check the production of the drugs and also check the trafficking of the drugs in India. So according to NCBR, National Crime Record Bureau, only in Bangalore in 2022, 3,913 kg of drugs is seized by the enforcement department. Recently, if you go to that Aryan Khan case, NCB, National Crime Narcotic Bureau, they seized only 200 crores of drugs in that single case, and the amount is more than higher in that particular year. So basically, it is a 1,000 crore business just only in few cities. That means if we calculate for the whole India, it is more than that. So to check that thing, this narcotic NDPS, Narcotic Drug and Psychotropic Substance Act was introduced. in 1985. So how they check this thing? By giving punishment. They categorized the amount of drugs in two categories. One is small amount, another one is commercial amount. So what is small amount, what is commercial amount? It is differ for different substances. Let opium 100 gram is the small amount and commercial quantity is 2 kg. For hashish or ganja, for ganja 1 kg is the small amount. For opium 300. No, no. Uh, yes, commercial amount. So like that ganja kg is the small amount, 20 kg commercial amount. So according, what you think that I am a consumer? So according to that amount, commercial or small, NDPS gives you that type of punishment. Yes or no? So basically, for small quantity, in general, you get the rigorous imprisonment for 10 years and 1 lakh of punishment. Sorry, fine. Yes, law is in concurrent list. So state has also the power to amend that law, to change in that law. But they don't change the union law drastically. But they can add the punishments for that thing. It might be changed, differ from state to state according to their amendment. And when the amount is a commercial one, in that case, you get maximum of 20 years of imprisonment and 2 lakhs of the fine. But according to the that what is your that substance is it opium, it is hashish, it is any other thing, heroin, it is changed according to your substance. So today we have discussed what is organized crime, what is terrorism, and what is this your narcotic NDPS Act and narcotic substance. So next class we are going to about discuss that fraudulent trade practice which include adulteration, and I think adulteration of food and adulteration of drugs you have discussed or you have read in IPC 272 to 275 or 6. Yes or no? So for today, this is all. Now your attendance is taken. So don't be in hurry. If you cooperate, it will be finished in some minutes. Okay. Thank you and have a good day, guys. Please listen. years general. Go to 4-2. Please listen and stay. 5 years general, room number 2. 5 years both. But ladies first, they go first. 5 years honors, room number 5. BBA and BCom LLB, room number 7. And 3 years general and honors. You have to stay here. So, please, girls first. Boys, please sit down. Boys, please sit down.